Hello, my name is Mohammed Khan, and the case that I have been given is the Regents of the University of California versus Bake from 1978. And let me give you some insight into this case. So essentially, during this time period in the 1980s, 1970s, um, there were a lot of desegregation laws that were being passed in order to give more minorities opportunities that they would not have. And in this case, we see that they were giving minorities opportunities, but there was reverse segregation going on, meaning, the majority, which was a white person, was not given the same opportunity that um, a minority had. And I'll get more into this in the next slide. Affirmative action. Affirmative action is a policy designed to increase opportunities for groups historically excluded due to discrimination. In college admissions or hiring, it may consider race, gender, or background alongside merit. The goal is not just fairness, but also creating diverse environments that benefit everyone. The issue. The issue is balancing fairness and equality. Should race or gender be considered to address past discrimination, or should decisions rely only on individual merit? Supporters see it as correcting systematic systemic barriers, while critiques argue it creates reverse discrimination and undermines merit-based opportunities. Alan Bake was a white applicant who twice applied to the UC Davis Medical School and was rejected, while minority applicants with lower scores were admitted under a special program. He sued, claiming reverse discrimination. The Supreme Court ruled in 1978 that racial quotas were unconstitutional. The regents of the University of California defended special admissions programs, arguing it was meant to increase diversity and address past discrimination. They believed affirmative action served an important educational purpose. The 14th Amendment. Bake's central claim was that the UC Davis quota system violated the Equal Protection Clause of the 14th Amendment, which mandates that no state shall deny to any person within its jurisdiction the equal protection of the laws. He argued that by reserving seats for specific minority groups, the state-run university a white denied him a white applicant equal protection by using his race as a basis to exclude him from consideration for those spots. And as you can see, this is the 14th Amendment right here. Let me just read it for you. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Title 6 of the Civil Rights Act of 1964. The University of California defended its admissions policy by arguing that the special program was necessary to remedy historical discrimination and protect educational diversity. They claimed that admitting more minority students helped train doctors who would better serve underrepresented communities and enrich the learning environment for all students. The regents emphasized that considering race was not meant to exclude others unfairly, but to achieve broader social and educational benefits. Essentially, what they were trying to say is that in this case, UC Davis is a medical school. So if someone graduates from UC, if someone, let's say, if a minority graduates from UC Davis Medical School, and they go to become a doctor, and they become a doctor, and so they could serve in underrepresented communities where there are less doctors and they need a lot more help. and this and they support this claim by using this Civil Rights Act. And let me just read it out for you. No person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. But in my opinion, they kind of do counteract this Civil Rights Act because they deny someone an opportunity based on the race. Precedent case: Swan versus Charlotte Mecklenburg from 1978 was a landmark Supreme Court case that upheld the issue of busing as a tool to desegregate schools, allowing federal courts to order such plans when necessary to overcome the legacy of past segregation. Supported by public policy, the court um, found that districts, sorry, found that districts have an affirmative obligation to desegregate. A divided court. The court's deeply divided ruling, with no single majority opinion, reflects the profound national tension between the principle of radical equality and the goal of radical redress. Justice Powell's controlling opinion, Justice Powell's controlling opinion crafted a legal compromise. He strategically joined one block of justices to strike down quotas as a violation of individual rights and another block to permit race um, permit race conscious admissions to advance the compelling interest of diversity. The Supreme Court's verdict was split. It struck down UC Davis's radical quota system as unconstitutional, but upheld the principle that race could be one factor in admissions. This allowed Allenbake to be admitted, while affirming that diversity in education was a valid goal under the Constitution. So essentially, they do two things. They do acknowledge that these, affirmative action is sort of unfair for people in majority races because it gives someone else a head start. But they also acknowledge that um, Allenbake is right. Sorry, yeah. They also acknowledge that Allenbake is right, and which is why they admit him, which is why he's admitted into the university. And now, as for affirmative action, they can't take down affirmative action because was a time that's very sensitive, and there were a lot of people, um, taking interest in this case. And affirmative action, if used correctly, I guess it's a very good thing for society. But since the court was pretty much divided in this case, they don't really have one specific verdict. They acknowledge both sides are right, and they do acknowledge that both both sides do need to work on some stuff. I mean, sorry, they acknowledge both sides are right, and the affirmative action laws by UC Davis do need to do better. How do I feel about this? I believe that we should neither discriminate against majority races nor against minorities. We should not be asked what anyone's racial slash ethnic background is on a school application at all. We should not let someone suffer for the cruelty of the past. Acceptance should be solely based on academics. So essentially, I'm just saying that, whenever we see a form and they ask, "What's your race? What's your ethnic background?" I think it shouldn't exist at all. Why does any of this matter? And that was my presentation. Thank you.